Now, you were talking about having pled guilty to charges related to the drive-by shooting or to the shooting on April 28th, 2015.
I pleaded guilty.
Excuse me, Judge. At this time, can we get the instruction, please? That's the first question directly from the state.
Yes. Ms. Levis?
Yes.
Okay. All right. Ladies and gentlemen, you are about to hear evidence that a co-defendant in this case has pled guilty to some of the charges in this indictment. I caution you that this co-defendant's guilty plea conviction itself is only admitted for a limited purpose. That guilty plea is an admission by this witness only that he committed the criminal acts to which he pled. You are not to consider the co-defendant witness's guilty plea as evidence that any other defendant is guilty of committing any of the criminal acts alleged against them in this indictment. Each defendant is entitled to have the issue of his guilt determined solely on the basis of the evidence against him and not on whether another person has been convicted of the same charges with which the defendant is accused. If you find that the co-defendant witness provided testimony on the stand that is inconsistent with his guilty plea admissions, you may consider the witness's prior inconsistent statement, that is his guilty plea admissions, including to the allegations in the charges to which he pled guilty, as substantive evidence, which you may consider against any defendant currently on trial for whatever bearing it may have on the issues on trial.
I think the state should have been prepared.
Thank you, Your Honor.
To do this instruction. Bruce stepped
So,
in.
Mr. Sledge, you mentioned pleading guilty to charges related to the April the 28th, 2015 shootings that you were just talking to the jury about. Do you recall that?
Yes.
All right. And when you pled guilty, did you do so in 2022 or did you do so in 2015 or 2017?
Officer, I pleaded guilty 2017.
Thank you for that. So, at the time that you pled guilty in 2017 to the charges related to the April 28th, 2015 shooting after Demekion Garlington was jumped, was there a factual basis given for that plea? Do you understand the question?
No, what you mean?
Okay.
I don't.
First, let me ask you, when you pled guilty in 2017, did you have an attorney?
Yes.
And is the attorney that you had then the same one that you have now?
Right.
And did you trust him then the way that you trust him now?
Right.
Right. And at the time you pled guilty, did the prosecutor tell the court that the evidence would show that on April 28, 2015, Mr. Garlington and Mr. Sledge were at a club called Club Crucial on Donnelly Hollowell Parkway earlier in the evening when members of, and preface this by saying Mr. Garlington, Mr. Sledge, and Mr. Zachary at this time were members of a gang called YSL or Young Slime Life that at some point had been affiliated with the Blood Criminal Street Gang. There had been a falling out carrying from the fall of 2014 into 2015. This, for lack of a better term, gang war was going on at this time. Mr. Garlington was jumped at the club by members of a rival gang, Aaron Mills, Dominic Carter, and others that are members of a gang which is a subset of If Gang or Inglewood Family Bloods, which is a gang that the dispute was going on with at that time, when Mr. Garlington was jumped and assaulted at the club. A decision was made by Mr. Sledge they called Mr. Zachary, the co-defendant, to retaliate in some way. The evidence will show that Mr. Sledge drove the vehicle. Mr. Garlington and Mr. Zachary were inside with weapons, and they first drove by Adele Avenue, 1428 Adele Avenue in Atlanta, Georgia. And that location at the time is the home of Darren Mills and his mother, and at least one of his sisters and one of his cousins, and is an address that Darren Mills actually used and stayed at. He was one of the individuals that had assaulted Mr. Garlington earlier at the club. Mr. Sledge drove by and they shot at the house. There were not individuals outside of the house, but the house was shot. During the shooting of that house, Ms. Denise Bell, who is the aunt of Darren Mills, while she was in her bed, sustained a gunshot to her buttocks and had to go to the hospital and had to have surgery. She was shot. The house was shot up, and there were other individuals there at the time, including Cecilia Davis and Diamond Mills. Diamond Mills being Darren Mills' sister. Also, the car belonged to Cecilia Davis, which was in front of the house and received damage. The evidence is that Mr. Sledge was the driver of the car. After that, Mr. Sledge drove over to 1903 Drew Drive, Northwest, an apartment there was at the time being used by Philip Collins, who is Darren Mills' brother, and also present at the club and participated in the assault. In shooting at what they believed to be Philip Collins' apartment, they damaged apartments 1122 and 1120. Natasha Battle's apartment, which was 1120, her patio doors, windows, and couch were damaged from the gunfire. Ms. Troutman's apartment was 1122, and that was the other apartment that was damaged. Through investigations, detectives got a lead that Mr. Garlington and Mr. Zachary were involved, and they conducted interviews.
Yes, sir.
This is going beyond factual basis for the investigation now.
I can pause there.
Okay.
Was that factual basis? Were those words read to the court by the prosecutor at the time you entered a guilty plea in 2017?
I don't remember, was it read by the prosecutor because I took a blind plea. And I think the judge read off the evidence. I don't recall what it was though.
Okay. Do you recall hearing those words read by somebody in court as the reason or the factual basis for the charges that were being brought?
If I can explain, I pleaded guilty because I felt like it was in my best interest. You had two co-defendants. Some of what they said was true and some they said wasn't true. But I did plead guilty because I felt like it was in my best interest.
Were you given an opportunity to say anything at the time that you entered that plea? Were you given an opportunity to make any statements?
No, not that I remember.
Do you recall the judge, after those statements were read, asking you, is there anything you'd like to say before sentencing? Do you recall that happening?
Yes, I recall him asking me that.
Do you recall telling the judge, no, sir?
I remember telling him, thank him for the plea
Okay.
that he allowed. I remember that. I remember me telling him, thank him for the plea that he accepted on the non-negotiable plea, the blind plea or whatever it was.
Would you explain to the jury what your understanding of a blind plea is?
Yeah, please explain.
A blind plea that I understood that you leave the evidence up to the judge and the judge determine on the sentence.
At any time, did you tell the judge, I'm not admitting this, I'm just doing this because it's in my best interest.
Well, I didn't tell
Problem.
the judge that. I told my attorney that. When my attorney asked me, like, when he came to me with the plea deal, and I told him, I said, why take the plea? Because it's best in my interest. You got two guys against one.
Hold on. At the time that you.
No, I didn't tell it to the judge.
That wasn't the question.
Oh,
At the time that you pled guilty, did you know what sentence the judge was going to give to you?
no.
Okay.
Not that I know, I just knew it was
Did the judge, or was it explained to you that you could receive up to the maximum sentence on each charge?
not if I understand. I think a deal was already worked out, if I ain't mistaken. That what made me take it. I think it was already worked out between my attorney and the state.
Do you understand the difference between a negotiated plea and a blind plea?
No,
Okay. Have you done anything besides a blind plea in front of a judge before?
The 2022 plea.
yes, I think I have, yes.
And when you pled guilty on December 28th, 2022, was that a blind plea or something else?
I think it was just a plea. It wasn't a blind plea though, if I'm not mistaken.
So everything she's holding in her hand that she just read onto the record as a factual assertion that he supposedly admitted to as part of a plea was part of a plea where he wasn't actually conceding guilt. The 2017 plea, everything about, Demikian Garlington gets jumped and beat up at Club Crucial on a Monday, Sunday, Saturday night. And he gets jumped. We don't really know who's doing it. Someone's house ends up getting shot up, possibly as retribution. And the facts alleged for that incident for which he took this blind plea, alleged, are not something that he signed off on and initialed as acknowledgments and assertions that she should be reading into the record right now. This is hugely problematic. And this doesn't apply to the whole day. Let's be clear. This has nothing to do with anything she's making reference to in the plea that he signed in 2022 for relating to this YSL indictment. But this, you're reading into the record as if it's a fact that these drive-bys have been asserted to, acknowledged as fact by someone that signed a plea deal. And that's not how Alford pleas work. With an Alford plea, you get to maintain your innocence. And she just read this stuff to the jury as if it was a factual assertion, rather than facts alleged on him as a defendant before he decided to take this plea. I'm surprised. I don't know if you saw the judge's face. And I'm honestly a little confused why the defense didn't object earlier since she'd already read it. I feel like they could have objected already. But this 2017 stuff, she just read onto the record that he asserted that there was a gang-induced drive-by shooting.
For a regular plea, what do you understand to be the terms? In other words, do you know your sentence before you plead guilty with a regular plea?
I don't know, because before the blind plea, I knew my plea.
Why did you then distinguish for the jury that it was a blind plea?
It was, but I already knew the sentence. My lawyer had already aware to me that they was offering the same thing. They was offering the co-defendants what they had pleaded guilty before me.
Okay.
So when I pleaded guilty, my lawyer aware me that they was offering the same plea deal that they gave them. But in my plea deal, I told my attorney that I didn't want the probation. I just take the straight prison sentence.
Okay.
Yes, sir.
Here we go.
All right, outside the presence of the jury.
I was waiting for it.
Yes?
Yes.
Okay.
So fourth
Excuse y'all
time.
for the jury room.
Fourth time they have to pause proceedings with this witness so far. because Love just read something into the record as fact that was not signed and sworn on. And this is really, so I am Shout, thanks for the super chat. This is what's so mind-blowing. How is she a chief deputy district attorney and she just did this? Like, this is what the defense means when they say that they're trying to goad us into asking for a mistrial. And it's like, you keep asking him, what's the distinction? Blind plea versus this. Like, didn't it dawn on you?
Yes.
Oh, the squeak. That's 15 for the squeak. I have to update the counter.
To do what? Sure.
Or is it 13? Because we didn't count 14. So it's going to be 14.
Yes, sir.
Thank you, Your Honor. Your Honor, I have a motion for a mistrial. The evidence has just come out that two co-defendants who, to my knowledge, at least one of them is not testifying and has entered a guilty plea. That is a confrontation clause violation to Mr. Williams and the other people on trial. In addition, Your Honor, gave an instruction with the last line, and I know it was objected to previously, but I want to stress this, that if it's a prior inconsistent statement, it can be used against Mr. Williams and the other people. That was premature because I don't believe there's anything inconsistent as of now. And then the third reason I'm moving for a mistrial in the aggregate, Your Honor, is that the prosecutor uses and reads the statement of the then prosecutor, I believe it was the Honorable Mr. Bailey, who entered this plea and gave a factual basis. But she did not make it clear that the Honorable Derek Wright said on page 12 of this transcript to the same court that Mr. Sledge is tendering the plea under Alford, which is ALFORD.
Yeah, I'm seeing the same thing. And honestly, I thought that we were going to be dealing with the guilty plea that he took in this
B-22.
case. And
Well,
yeah,
sorry,
it's probably
look, he just
took in
said,
this case.
so did I.
And
If you can't hear that, Steele just said, so did I. I thought we were going to be talking about the December 2022 plea deal. As Whitaker just said, the one in this case. Steele, it was quiet. If you guys there's no closed captions on this. He just said, so did I. And look at his face. I believe it. I do think that they're going to call this mistrial. But I think that they might have been figuring it out as it was happening. Talking about this 2015 shooting and didn't realize that this wasn't actually text in that 2022 plea.
yeah, that's problematic that this 2015 case is an Alford plea. And so I don't think that any of what I said with regard to admissions is actually true, even against this. I mean, he's saying he pled under Alford, and I don't know why the disposition sheet doesn't say that, but it is very clear that this is an Alford plea in this 2015 case. So Mr. Wright wants to share something. Yeah.
And let's be clear here, right? The issue, I just expressed it a few minutes ago. You guys are echoing it in the chat. Love was asking these questions, saying, oh, can you distinguish between why this plea in 2017 was different, or for a 2015 incident, the plea you took in 2017, why that's different than the plea you took in 2022. She kept asking that question. So right here, when Whitaker's saying it's obvious reading it that this is an Alford plea, even if it's not spelled in bold text, the word Alford written all over, watermarked all over the page, you should have known it. And here Love was reading it onto the record. And hopefully maybe she looked at this while planning her strategy of questioning today. And it still never dawned on her, even after arguing all morning about limiting instructions for the 2022 plea, which is not an Alford plea. But you see how contentious that plea was. You read in this 2017 plea and you're reading it and you're asking the question that points to, oh, maybe I shouldn't be reading this into the record as factual assertions, factual acknowledgments. And you just keep going with it, you don't realize. That's what's so stunning about it. Like, how could that not be willful? It can't just be incompetence. Chief Deputy District Attorney, that has to be willful.
Yes, sir.
Waiting for the appropriate time that I was going to point out that it was in fact an Alford plea. So I thought her cross-examination was not appropriate.
Well, y'all, I mean, maybe that, yeah.
It was something other than an Alford. So
Well, maybe don't wait so long next time. But, I mean, I'm definitely going to, Ms. Lev, do you want to be heard?
Yes, please.
All right, go ahead.
One, we'd ask that the court deny the motion for mistrial. Number two, we would ask, as it relates to the assertion that no inconsistent statement was made, in the factual acknowledgments.
Okay, no, see,
Not
that's the deal
acknowledgements.
with an Alford plea, is you are not acknowledging that the facts are true, like you would in a regular guilty plea. You're saying, I think that the state has enough evidence that a jury could be convinced beyond a reasonable doubt that these facts are true. But
Yeah.
you're not acknowledging on your own, yes, these are true.
Your Honor, when
Yes.
I spoke of the factual acknowledgments, I meant 444Y.
Well, that's what I thought you meant.
Within 444Y, we referenced this particular
All right, let's,
section.
maybe if you can point me specifically, let me pull that one up.
Page
Which number? Go ahead.
number 3 on page 3 of 7, under defendants factual, I'm sorry, not number 3, number 4, on defendants factual acknowledgments on or about April 28, 2015, as reflected in Fulton County Indictment 15 SC 138994, defendant and fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL.
Okay, and so those factual assertions, what I read as the limiting instruction would be true for.
And
But the
2022.
factual basis that you just read out from the 2015 one, that's a whole lot more than what's in numbers 4 and 5.
Your Honor,
She did not mention any of this morning through more than 30 minutes of the recess and research and arguments. I'm honestly so annoyed that this is not, you ever see those judges that keep it cool and then they snap? This is a moment for one of those judges where there should be a snap. Like, we argued about this morning, and then you did this. And you guys are right about Hilton's body language. Like, Hilton knows this is not what we should have been doing. Maybe she knew and should have stopped. Maybe she just looks this way because Love got called out for it. I don't know. But something about her body language makes it seem like, Love, you just did this. And the judge has a very calm tone here, and I would not as a judge.
in number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in section 3, 4, and 5 above.
Okay.
And So if I'll, of course, comply with whatever appropriate instruction that the court deems necessary to give as it relates to the conviction of this witness for 15 SC 1
Is this an on the knees moment?
38994, but given the factual acknowledgments that were made as it relates to 22 SC 1835572, and the fact that this witness did not assert, even though the plea was given in his best interest, he was allowed an opportunity to say what he said here, and he did not say it.
No. When a defendant has an attorney who is saying, we are pleading this because we believe it to be in his best interest, the defendant does not then independently need to say, yeah, by the way, judge, here's what Alford means. So
Understood.
no. Are you going to
So we also don't know what agency means, representation means. Love just has her own dictionary.
tender for admission any part of 444Y
Yes, the state intended to tender 444Y.
in its entirety?
Yes, I
Okay.
did.
In objection to that being tendered or admitted in its entirety?
And if there is an objection to it, then
All right,
we would
let's
just.
find that out.
Okay.
You got it. I don't know. It's not my fucking case.
Oh! What? Hold on.
You got it. I don't know. It's not my fucking case.
I didn't know it's not my effing case. And then is that Westmoreland saying something you? Do you? Hold on, guys. Decipher this. And if you're going to type it in the chat, censor the F word. We're going to do my 90s buffering thing. My 90s kid buffering. What are they saying there? This is not my effing case. No, that sounded like Bruce Harvey.
To that being tendered or admitted in its entirety?
And if there is an objection to it, then
All right,
we would just.
let's find that out.
Okay.
You got it. I don't know. It's not my fucking case.
I know they leaned in. That sounds like Bruce Harvey's voice to me, you guys. I know they happen to be leaning in, but it doesn't look like Hilton's mouth is moving when the woman speaks. It sounds like Harvey and Westmoreland. So I know it looks like they're leaning in and getting hot mic'd, but I think it's Harvey and Westmoreland. Oh my gosh. But yeah, I didn't know that's not my effing case. So...
I just don't, yes, I object at this point to the entirety of the document unless the state can give reasons for which parts of the document are admissible at this time. And if they're not tendering yet, I understand that. But I can't get around how we got here. I'm
Read
trying
into
to
the
follow
record.
this factual basis, and I realize I asked Mr. Renard, Renard, for this, and we're in a different case.
Yeah, we are. So, we've been talking about these 2015 crimes, and we've been talking about, what's been going on in this 22 indictment. So, I guess that's how it came about. But I wish we'd been a little more specific about it all beforehand, because I noticed this morning that this was an Alford plea. And I would have had issues with when you started reading out the factual basis. I'm thinking, well, is this some other case that I don't know about that's not the 2015 case and not the 22 case? Because we should have been reading the factual basis from the 2015 case.
Your Honor, the 2015 case, I understand what the court is saying. The 2015 case is one of the overt acts that we allege in the indictment. And as it relates to the defendant's conviction for the 2015 case,
Mhm.
we believe that it would be appropriate is an appropriate matter for cross-examination, and it appropriately falls under the portion of the court's instruction where it tells the jury that the conviction itself is not to be considered as evidence. And to the extent that Mr. Sledge is asserting that he didn't do it, that he dropped someone off, that is what he asserted, by the way. He said that he was not present. He dropped him off and it was only one house.
Well, we all know how party to a crime works. So, I mean, yeah, he said, I didn't shoot, but he
said
did
he
admit
didn't.
to being the driver.
And so to the extent that he said that the statement contained in his factual acknowledgement that he and fellow YSL associates, and I'd also point out that early on he made a very blatant inconsistent statement that YSL is not a gang. And in this factual acknowledgement
All
section,
right, we're not going to use anything in the factual acknowledgement section of the 2015 plea.
no, in the 22 SC 183.
Okay, yeah, no, I mean, all
We're
of
changing
that that is
subjects.
inconsistent with any of his trial testimony is fair game for you to tender for admission and for them to consider as substantive evidence against everybody. The issue we have that needs to get cleared up is that before I read this limiting instruction, I thought you were going to tender the guilty plea to this 22 SC case. And it turns out that you were talking about the 2015 case, which I understand you're saying we did part of that as, part of the 22 factual acknowledgements. So those factual acknowledgements in there are fine as well. When I say in there, I mean in this 22 case. But I'm going to have to clarify for the jury that what I told them about prior inconsistent statements
does not apply.
Does not
to-
apply. And that everything you just read from that guilty plea also needs to be disregarded.
So, Your Honor, as it relates to the court's instruction to the jury regarding the inconsistent statement not applying, we would only ask that the court specify that the court is speaking as to the factual basis that I asked the witness about in 15 SC 138994, particularly where he has testified and he pled in his best interest.
Okay. And you haven't tendered yet the 444Y. And so at the point in time when you tender that, then I'll say, okay, for this one, this
Okay,
is true.
I see what, yes,
Okay.
yes.
All right.
Now
If
it's
anybody
going
wants
to like
to
acknowledge.
suggest specific language, I'm willing to listen. Otherwise, I'm just going to kind of
And,
give it my best shot.
I would
and
like,
Your Honor, may I say one more thing?
Shut
Yeah.
up.
Because number one, the court has previously instructed the jury that questions, and I understand the content of the question needs to be addressed. But given that the witness has testified that he pled guilty in his best interest, and given that he can also be cross-examined as to whether or not he can, he was asserting these things, we don't believe that anything beyond a instruction regarding the factual basis for 15 SC 138994 not being considered a statement of the witness rather is required.
Okay.
I just respectfully don't think that goes far enough. You know, you have a prosecutor who's saying it's just a blind plea. She leaves out everything about Alford. She elicits, and I'm not saying that she could have anticipated this, but her questioning elicits that a non-testifying severed co-indictee pled guilty also. That is a total confrontation clause violation. It's the second time.
All right. And that's Zachary and
Well, Mr. Zachary, I anticipate may testify.
Miki
Right.
and
I don't know.
Garlington.
He hasn't yet, but it definitely includes Mr. Garlington, who the state has said will not be testifying. And then just for you to know, you were not here, but the predecessor judge permitted over objection the state to do the same thing. They did it with a Mr. Winfrey, just like the court reporter's last name. He's not going to testify. No one believes he's going to testify. The state doesn't say he's going to testify. And they got out that he pled guilty. So they're aware of all this. And in fact, the state elicited in that case that the gentleman, Mr. Winfrey, pled guilty to avoid plea. It was vacated by the Supreme Court of
right.
Georgia.
Yeah, I remember you.
So, and
Didn't
then
he enter another one after the fact, though, anyway?
5 years later, Alford Plea, and said I'm
Okay.
specifically innocent.
Yep.
I mean, it was a farce.
Right.
And then the predecessor judge wouldn't even let me examine the witness. And Miss Love said that the witness I could call in my case in chief on direct. So the reason I'm bringing that up is this is not new.
Okay. What's your intention with regard to Mr. Garlington? Do you have any intention of calling him?
Your Honor, no. And Mr. Steele is absolutely correct in terms of the witness testifying about Mr. Garlington and Mr. Zachary and his doing that. There's nothing that indicates that the only reason he did that was because they pled guilty. So that is not, in other words, his statements that he gave to the jury about Mr. Garlington pleading guilty and all of that are not something that I asked him about or expected him to be talking about.
Right.
Hold-
Okay. But
Okay, no, Whitaker, that's not true because she was asking him to distinguish. So he said part of the reason he wanted to plea the way he did for that 2017 plea about 2015 was because he knew he had two other co-defendants. So his answer to distinguish what was going on and why he pled that way necessarily would include a mention of the other two co-defendants. So no, that's not right, Whitaker.
But nonetheless, we have that now before the jury.
We would
So-
ask that the court tell the jury to strike, disregard, put out of their mind anything about the Mr. Garlington pleading guilty.
I'm just going to say anyone other than the witness on the stand.
Okay.
Your Honor, if I could be heard.
But Mr. Zachary is a witness.
I know that, but he hadn't been called yet, has he?
No.
So
no.
deal with it when he gets called.
Yes.
Yes, sir.
Your Honor, on behalf of Mr. Sledge, clearly at a jury trial, we are always assessing the credibility of witnesses. My client has now been impugned, or at least attempted to be impugned by the state by suggesting that either he should have been making a statement or his plea was something other, or that these facts are in fact his admitted facts.
I'm going to make it clear that that's not the case.
And that's where I want to make absolutely clear that he was right in the position he was taking, that it was in his best interest.
All right. Anything else before we get the jury back in?
Let's run to the bathroom.
That is a great idea. Let's all do that. Or take
just-
that opportunity.
Did Love just giggle about the bathroom break?
Okay, that is denied.
And then because you're giving curative instructions, maybe instead of making the same motion to review it before acknowledge that I would have done that and then still do the motion for mistrust.
Yes. All right, let's take 5 or 10 minutes ourselves.
Judge, I fully adopt on behalf of Mr. Nichols, and I know I don't need to under the rule we're operating under, the motion for mistrial. I understand your ruling. I understand you're going to give an instruction, but I ask that as part of that instruction for an admonishment under 17-875, and I think that admonishment is mandatory, where counsel makes statements of prejudicial matters which are not in evidence. And I believe that this applies to this particular instance under these particular circumstances. So I'd asked the court to admonish counsel. Yes, in front of the jury, obviously, as part of the instruction.
All right, give me a second to get signed into Lexis and take a look exactly at what the statute says. Give me that site again. 17-875. I left out a number. Do you have any suggested language? I'm sure you do. That would be appropriate for the court to give at us as an admonishment.
I haven't, we can come up with something.
All right, well,
pretty quickly, I guess.
let's endeavor to do that right now.
Is this going to be a while?
The drive-by shooting
Oh,
on
no, okay.
and Your Honor,
My bad. Here we go.
Go ahead.
now, okay. Your Honor, given that 17-875 refers to statements of prejudicial matters, which are not in evidence, and the factual basis given or read by the prosecutor in the plea in the 15 SC case, while containing details that are not contained within the factual acknowledgments of 22 SC 183-572, it contains, it's about the same act, which in the factual acknowledgments for this case, the defendant says occurred. He admits and acknowledges that he, Demekion Garlington, and Quindarius Zachary committed a drive-by shooting at this residence, and that they committed the drive-by shooting on behalf of YSL and to increase the notoriety, reputation, and fear of YSL, and that he admitted and was convicted of aggravated assault, participation in criminal street gang activity, and among other charges for his participation in the drive-by shooting referenced in sections 3, 4, and 5. And given that this evidence will be properly before the jury, our position is that these statements, the questions that I asked, which contains the factual basis, the assertion about the factual basis in the 15 SC case, would not be a prejudicial matter.
It sounds like he was improperly advised on his 2022 plea agreement. Am I hearing this right? She's making the argument that his 2022 plea agreement included an acknowledgement, an actual acknowledgement, that he pled guilty to that specific act, that 2015 drive-by. Well, if that was actually an Alford plea, and he signed a plea that said otherwise, that he actually pled guilty to that act as charged, that sounds like there's a problem in the 2022 plea agreement. Maybe I'm not hearing her argument.
Though the factual basis is not in evidence, the fact of the shooting is not a prejudicial matter, which mandates a rebuke.
Okay. Well, the fact that a co-defendant who may not ultimately testify and who you do not believe will testify has pled guilty.
I don't disagree that
Okay.
that should go, but that was
So-
not something that I.
No, I know. I don't think that you intended to elicit that. But yes, I'm going to give a rebuke. Ms. Love, I mean, that's just what it is sometimes to be the prosecutor in a case. Got to have a tough skin. Suggested language, Mr. Harvey or others?
Need for some smarter colleagues to give me some suggestions, which is everybody in these three tables.
And Your Honor, I'm still reading under the annotations of that particular statute
Yeah,
regarding
but you know,
the rebuke.
we also
language.
presented this, by the way, as a guilty plea, not as an Alford plea. And we read a factual basis from something that's not in evidence. It is so highly prejudicial that we all made a motion for mistrial. A rebuke is in order under 17875. And I think the court in front of the jury can say, and I hereby admonish the state for bringing up these matters that I have just told you to disregard. And the state should not do that again.
Your Honor, what the annotations say is what the law forbids is the introduction into a case by way of argument of facts, not only not in the record, but that are calculated to prejudice the accused. And
All right, Ms. Love, I'm going to give some sort of an admonishment. And I mean, sometimes you need to just, keep your powder dry and not argue every single thing to the nth degree. I've already said I'm giving it. So, I mean, I can grant a mistrial if you'd prefer.
oh no. I do not
Okay,
want to
then
mistrial.
maybe stop arguing at this point.
Yes, Your Honor.
Okay.
Look at her cheekbone.
Now, in terms of her having presented it as a guilty plea, an Alford plea is still a guilty plea, so I don't find there to be anything wrong with her having referenced as it a guilty plea, but, we already talked about the whole factual basis thing, so I won't rehash that, but, okay. All right, and after I give the instructions, I'm going to ask y'all, I understand that the mistrial motions are preserved, but I am going to ask, since I haven't read out yet what I'm going to say, if y'all have any suggestions that you think would further elucidate, clarify, cure anything. I'm going to ask you for that. And if you have them, I would like for you to let me know that, and we can come up to the bench and consider any other further curative instructions. Okay. All right. All right. Let's get the jury back out. And I mean, I don't know that we need the witness in here for that, but
Will the court
Here-
prior to
go ahead.
bringing in the jury, would the court be willing to read the
What I'm going to
rebuke?
say, well, I don't know what the rebuke? I mean, it's probably going to be something to the effect of, after I explain to them what they're not to consider. I also admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and to what you put before the jury. Mr.
Oh my
Harvey
God.
wants more. What else?
Hold on. Was she quiet? Did she just not respond to something? She just put her head down. I know when I replay it, it's going to give me the buffer. But she actually just sits quiet and puts her head down. She doesn't actually respond to that. That's a once-in-a-lifetime reaction from Love.
I also admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and to what you put before the jury. Mr. Harvey wants more. What else? I'll consider it.
You should be banned from asking any more questions ever for the rest of the.
Well,
For the
okay,
rest of my life.
reasonably speaking, though.
That may be going a little bit too far. But that's already been asked for, by the way. And that the court, in giving these
Look at the table
instructions,
back there.
intends to rebuke the state for asking for eliciting that improper testimony.
So, Your Honor, it wasn't improper testimony. It
Okay.
was the question.
Improper statements of the state. That's the whole point of a rebuke. That's the whole point.
And we would ask that the court if the court is going to read, that the court reads only what the court initially said.
Look at Hilton. Look at them all. Look at everybody in this room right now.
She should be shot.
I will say you should not have put that factual rendition before the jury as anything this witness admitted to. Mm-hmm. I'm listening.
At the time he pled guilty
Okay.
in 2017, because
I understand.
Your Honor,
Give me just a second. Sorry.
Look at Weinstein just looking like that all
Yes.
happened.
let me request that the court consider including in its admonition the following language, if the court deems it to be appropriate. Somewhere in there, the presentation of that evidence that I've described was improper and was not in keeping with the law and the prosecutor's ethical obligations. Accordingly, the state is admonished for their behavior and is instructed to refrain from asking or presenting any improper questions or evidence moving forward.
All right. I'll do a little bit of it, but not all of it. What was that last sentence?
I like the first sentence.
I'm sure you do. Instructed to refrain from what?
Refrain from asking any improper questions or presenting improper evidence.
All right. Well, they're not presenting evidence, so.
And
All
must, and should conduct themselves within their ethical obligations
All
and
right.
legality.
Thank you. I'm not going to do that.
All right, I got some more.
Got some more? All right. I think this is going to be enough. All right. Let's get the jury out.
Witness back first.
I mean, do y'all want the witness in here for this?
No, Your Honor.
Okay, let me ask you a question. Have you or somebody instructed maybe even Mr. Wright, the witness, to not talk about anybody else's plea to anything? Can Mr. Wright just do that? All right, let's get the jury out. All right, ladies and gentlemen, I've got some further instructions for you with regard to some of what you just heard. So I gave y'all an instruction that if this witness provided testimony that was inconsistent with a guilty plea admission, that you could accept that guilty plea admission as substantive evidence against any of these defendants. But then what we heard was that this witness pled guilty in 2017 to that being a part of that 2015 drive-by shooting. But and we heard kind of a factual basis that the prosecutor in that guilty plea had read before the court, or somebody had read before the court, as a part of what Ms. Love was asking questions about, and she was, kind of reading it from a transcript. All right, here's the thing, is that guilty plea, as I think you heard this witness say, he entered that because he believed it to be in his best interest to do that. And this gets into a whole lot of kind of legal terminology and legal concepts, but there are a couple of different ways that somebody can say, yes, I'm pleading guilty to a crime. And one of them is called an Alford plea. It's just named after a case called Alford. But they're essentially saying, I am going to plead and accept that I'm guilty of this crime, but I am not saying that the facts that the state's putting forward are true. I am just saying, I think it's in my best interest to go ahead and resolve it that way. So everything that you heard and that is totally legitimate to do that. And let me also say that Mr. Wright, who was representing this witness at the time, he let the court at that time in 2017 know, hey, this is an Alford plea. He's doing this because it's in his best interest, he believes, to do this. And Mr. Sledge was under no obligation after his attorney said that to, even if he got an opportunity to say anything else, to say, yeah, what my lawyer said, to add anything whatsoever to that. So I think there was a question about that, and he didn't, he didn't say anything else. He had no obligation to, he had no requirement to, he had no responsibility to, okay? So basically what I told you about, you can take those facts and those admissions and consider it against him or anybody else in this trial. When it's an Alford plea, you cannot. So none of that I said was actually true about what you just heard about those 2017 guilty plea to the 2015 drive-by shooting. Okay. So let me think what else. Oh, and you also need to completely disregard that anybody other than this witness right here, Mr. Sledge, might have pled to anything that had to do with that drive-by shooting. All right. So just entirely erase that from your minds. And I also, at this point, am going to admonish and rebuke you, Miss Love, to pay careful attention to how you ask questions and to what you put before the jury. You should not have put that factual rendition before the jury as anything that this witness admitted to at the time of the 2027 guilty plea. And I'm going to instruct you to refrain from asking improper questions.
Yes, Your Honor. Thank you.
All right. Anything in addition that anybody needs to put before the court right now with regard to those curative instructions? All right. All right, go ahead, Ms. Love.
Mr. Sledge.
Can't even get it together.
Would you tell the jury? Just one moment.
Sure.